This is a relatively short but interesting divorce hearing. There's quite a battle over child support and insurance. Mom's providing insurance for the kids, but it's not great insurance and it costs a lot of money. Dad doesn't have the option of providing insurance, but Dad's girlfriend, wife, stepmom, whatever she is, does. Very cheap, and it's a good policy. Can the court obligate the stepmom to provide insurance through Dad? Interesting question.
We are going to go on the record in Sarah Hoffman versus Christopher Casilla. It is 2018 DM 127. The plaintiff appears in her attorney's office and with counsel, Mr. Thompson. Mr. Von Aken, is your client with you?
He's seated directly to my right.
Okay. And then who is Leah Cornett?
Your Honor, my name is Leah Soretti. I'm a DCF contract attorney.
Okay. I haven't met you before. Hello.
Hello, Your Honor.
Thank you. Thank you for doing the good work. Mr. Von Aken did this kind of work for years, didn't you, Mr. Von Aken?
I did. It's how I got my start, Your Honor.
Yes. All right. Speaking of which, first, tongue in cheek, though, I'm going to say that if you two were my children, I would say somebody's lying, but I won't say that. And we'll just move on to the motion to settle and the response. And I am ready and able, I think, to rule without argument unless you request argument. Okay. So, first of all, the court is going to adopt, of course, the recommendations of Jeannie Erickson and those matters that have been agreed to through case management, and allow her or order her withdraw. I think under the new Supreme Court rules, 3 years is the limit. I don't know that it's been 3 years, but frankly, Ms. Erickson is trying to reduce her workload, not even related to this case. Sometime back, she sent a letter saying she didn't want any more highly contested appointments or high conflict cases. And so I'm going to allow her to withdraw as case manager, which means we won't have a case manager. We'll be back to, where we were. And figuring it out as we go along.
And Your Honor, I anticipate filing a motion to appoint a case manager if the court's not so inclined to do that today.
I think we're going to go back to either mediation or LPC, not LPC, but conciliation, domestic conciliation. I'm not going to just, I think I'm supposed to be limited in terms of case management. I don't think that means you just switch case managers. You could look at that and tell me if you have a little different interpretation, but they should have the skills to be able to do much of it. We've got to have somebody new, and I don't think I'm going to make the statutory findings right now that triggers the case management provisions. But if you want to file something for reconsideration or file a brief or do something, you're free to do so. I am obviously going to let her withdraw, and my thoughts were we'll see if they can mediate. If they just absolutely cannot mediate, then we need to find someone that we can assign to do conciliation. So, all right. With regard to settling child support, the court is going to order $339 a month in child support from June 1 of 23 to October 31 of 23. And I believe, I'm not aware, it looks like it's 335 from November 1.
Your Honor, the
To
issue,
present.
well, the issue
What?
with that, is
I'm sorry.
there is a credit that Mr. Casilla is providing for health insurance for the minor child. And it
Yeah,
looks like
I'm gonna get to that. I'm gonna get
Okay.
to that.
that's where
All
I
right.
think the 335 comes in.
Oh, so it should be 339.
Correct.
Okay, so I'm ordering the
That's,
three.
Your Honor, that would not be correct. The 339, both parties submitted worksheets. The 339 for both parties
Oh.
goes through October 31st. The difference is in the time period from November 1 to now, whether there's and I
And Your
will,
Honor, I misspoke. Mr. Von Action, I misspoke. I thought you were referring to Mr. Von Action's number, which is 319. The 335 is accurate, your number. My apologies.
Okay. Now, obviously, this is a hot topic, so I guess I'll just go there. I am not going to give Mr. Von Aken, your client, any credit for insurance through his wife. This is why. First of all, a step-parent has no duty, legally or otherwise, to support a child. Secondly, I have no jurisdiction over her in the event that she should fail to keep up with the insurance or she should terminate the insurance. I only have jurisdiction over the parties, and they're the ones with the duty to support and provide insurance. If your client wants an additional layer of coverage and has secondary insurance to reduce any out-of-pocket that he might pay, he's free to get it, but he's not going to get credit for it. So that's
Your
where
Honor,
that's.
okay, I understand that. Have you reviewed the child support guidelines? Because I think the only thing that is discretionary is whether the coverage cost is reasonable, and we're talking about $20 a month. We're not talking about, I think that's where the discretion for the court lies, but if a party's providing insurance, and the only reason that we're asking that the court ordered for the insurance to double cover is it does a couple of things there. One, the issue with insurance has really been mom's issue because she's had 3 different jobs in the last year, and there's been concerns about lapse of coverage because she's changed jobs so frequently.
Has she ever not had coverage? Has there ever been a lapse in coverage?
I have no idea, Your Honor, because it hasn't been reported whether or not Mr. Thompson hasn't provided that information. The other thing it does,
Your Honor, if you would like for me to answer my client, there has not been a lapse in coverage, Your Honor.
You know, $20 isn't tons of money if it saves your client money by having secondary coverage. I mean, given the fact she's not gotten any child support for almost a year, I mean, really, come on. I mean,
yeah,
and Your Honor, my argument is because Mr. Thompson wouldn't engage on getting it resolved. I had to file a motion. This is the second time I've had to file a motion on child support because
Mr.
he
Von
won't do
Aken,
his job.
I think you've been in the business long enough to tell your client to pay something. $50, $75, I don't care what, but you pay something, and you probably should pay what you think you owe. And the court could live with that. But just to go an entire almost year and not pay a dime is just, I think it's contemptuous, actually, even though I don't have a contempt motion in front of me. And you could probably defend one because there was no existing journal entry. I just find that kind of behavior unacceptable. And I would say that to anyone, and especially in this case, we've got this child support down low enough to not pay anything for almost a year to the mother of this child who has primary residential custody. Is just, I don't even think he has an argument to make in that regard. But let's get this cleaned up and cleared up. I mean, I guess you can appeal that I'm not properly interpreting the guidelines. I don't see a situation in which a judge should place upon a step parent to provide primary insurance. One, it would have to be voluntary on their part. Two, the court has no jurisdiction to enforce it. None. So I don't see how the legislature or the Supreme Court rules or anyone else can force me to make an order or agree to something that I cannot enforce within a case. And this is not a case where there isn't insurance. There is insurance. And I think that's intended for parties, not third parties. I understand she's a step parent, but she has no legal obligation whatsoever to this child. So unless Ms. Thompson wants the additional coverage and the $20 deduction, fine. Otherwise, I'm going to find that her insurance is satisfactory.
And
I
Ms.
don't know
Hoffman,
this for a fact, but I've heard this because I've never had my children or anyone double coverage, unless maybe they had a medical card plus they had a layer of private insurance. But sometimes double coverage can cause you more problems than it's worth because they're always pointing the finger at each other as to who should be paying and who should be paying what. And that can be a nightmare, especially if you have two people who don't work together very well. So they can't sit down with the bills and go over them. They're trying to avoid paying as little as possible. Whatever the case may be, it's hard enough to navigate secondary insurance when two people are working together on getting the bills paid, let alone where there's no communication. So,
Your Honor, I will point out, this is the same insurance company. They're both covered by Blue Cross, just different plans because of the employers. And the difference in the deductibles and maximum out of pockets are markedly different. And that's another issue because you have to determine the reasonableness of the insurance. And in the worksheet, the number assigned, because Ms. Hoffman's employer does not require that employees pay for the insurance, that is 100% of the family plan cost on the worksheet because that's the way we have to calculate it. Whereas the $20 a month is on a 4-person plan with a in-network deductible of $3,200 and a maximum out of pocket of $8,300. The corresponding numbers for her plan would be $6,400 for the maximum out of pocket for the family and $12,700 for the maximum family out of pocket. And it's a high deductible plan. So until you hit the deductible, you're paying 100%.
okay, well, I understand your argument, and I don't find that it's reasonable to place a requirement upon a step parent to cover a child of the minor parties. And I don't find that the court can enforce that, nor can the court penalize either party for a failure on the part of the step parent, and they have no legal obligations or duty.
But Your Honor, you would be ordering him to carry the insurance. And because he would be doing so through his spouse, it would be his obligation if for some reason the spouse's coverage were to drop.
I'm not doing it. I'm not doing it. So if you want to appeal it, go ahead. But I think the responsibility to insure a child is upon each parent. And if your client were working and had insurance coverage and it was a better policy, I would find it more reasonable and allow him to carry the coverage. But he doesn't. He doesn't work. And I am not going to place or put in the hands of a step parent the requirement or responsibility to keep a child insured that is not a legal obligation of a third party that I do not have any jurisdiction over. So that's my finding.
Thank you, Your
All
Honor.
right.
And, okay, sorry.
So I've already made the finding about child support. I've made the finding about the insurance. I am denying the respondent's request for attorney's fees. I'm also denying at this stage the petitioner's request. However, I'm requiring by June 1st that your client, Mr. Van Aken, be current on child support. In the event that he's not, then I am going to award any attorney's fees that are necessary or associated with trying to collect that judgment.
Understood, Your Honor.
Your Honor, I know it's obvious, but in this case, seems like the obvious escapes us sometimes, but June 1st, 2024, correct?
Yes, sir.
Thank you, Your Honor.
What else do I need to take up today?
I think the only other thing that I had on there was an objection to the recommendation regarding the split on the counseling costs that Ms. Erickson had recommended. I think that was outside of her purview, and there was already a medical order in place regarding dividing it by percentage of income. And my client received the EOBs for that this morning.
Okay, I'm fine with that since I'm ordering that he be current on child support as ordered today by June 1st. I'm fine with doing it that way.
I'm sorry, Your Honor. Doing it which way?
Splitting pursuant to
Okay.
previous
And
orders.
if he is not current by June 1st, is 100% of the cost on him for these co-pays? My client's been fronting him with no reimbursement.
No, I think there should be a motion for contempt and the court should look at putting him in jail.
Thank you, Your Honor. That was my next question, I do not anticipate an appeal, Your Honor, but for the record, in case Mr. Casher decides to, we do not believe it appropriate for Mr. Casher to receive the multifamily adjustment. I understand the court's order. That's just to preserve any objection for appeal in case Mr. Casher does it. We do not intend to appeal anything, Your Honor. But,
and Your Honor, the guidelines changed January 1, and exactly what I told the court last year is the truth, is that is no longer an issue regarding granting a multifamily adjustment for a new child in the payer's family. So I don't know where Mr. Thompson's going with that.
This is going back to last year in 23 with different guidelines. I just want to preserve that objection, Your Honor.
I understand. And what he's saying is if you're going to appeal child support and all aspects of it that I've ruled upon or any aspect of it, he wants to be free to do anything and clarify because, you know, we've got, I don't know, what, 8 more years of this, 7 more years of this.
9.
So anyway.
Thank you, Your Honor. Does the court want a journal entry prepared or will the court's disposition sheet serve as the court's order?
No, we need a journal entry. We need a very clear journal entry.
So would you like to prepare that?
Well, I don't know. Does somebody want to volunteer?
I'll take care of it, Your Honor.
Okay. Leah, is it Soretti?
Yes, Soretti, Your Honor.
Soretti. Do you have any input, any comments or anything with regard to child support? I didn't give you a chance to brief any of these issues or to do anything.
That's okay, Your Honor. I really just wanted to ensure that we settled the issue of child support today. This came across my desk to refer or to basically review for contempt based on the fact that there had been no payments made since 6 of 2023. But I saw this hearing was upcoming and just wanted to ensure that we came to a final order. I agree that a journal entry is necessary. It needs to be very clear, especially the repayment of arrears and the due date for that, so that our finance department knows how to accurately obligate the new debt.
Okay.
So yes, thank you for giving me an opportunity.
Okay. And of course, send the journal entry to her for approval as well.
Yeah.
Because I think the law is still clear that when we talk about child support, we can't leave out the 4D attorneys. They have to be
Correct,
noticed
Your
and
Honor.
involved.
I'll send a copy to both counsel and for their approval.
Okay. Okay. All right. And then when an issue, the child's still an independent, right?
Yes, Your
I
Honor.
think so.
Yes, Your
Okay.
Honor.
So I know that's not cheap, but there couldn't be a better private school, in my opinion, that the child could be going to. So they shouldn't be fighting about school per se. And this is the track they've been on with him for a while. But if something does develop with regard to issues that need to be resolved between the parents, let's get together and decide what direction is best and frankly cheapest for the parties. Because I'm sorry, I don't know why I always have trouble with this name, the mediators in Andover.
That would be the Myers, Your Honor. Is that the ones?
Yes, but what's
Yeah.
the name of their company? It's
It's
mediation.
Collaborative success.
Yes, they are very thorough. They're very good, but they can cost as much or more as Jeannie Erickson. So
Right.
they are not. I've got folks who are paying anywhere from $2,000 to $5,000 a piece, and so that's $10,000. And I just don't. I would like to cut their other costs back as much as we can. And so when something comes up, if the attorneys can't resolve it, I would say that should be your first plan of attack. Is we've tried to resolve this, we can't resolve it. Give it to your attorney, let them contact the other attorney, see if they can come to an agreement. Then if you can't, then let me know, and you'll have to propose, how you believe that we should proceed forward with their whatever parenting issues they have. Okay. How are they communicating? Family Wizard, or I don't want to stir up trouble here, but
I think they're still using because they were having to communicate with Ms. Erickson. It's been entirely by email because they were having to do that connection.
so
with
now
her.
they're losing that
Correct, Your Honor.
Correct.
oversight. So I think they need to go to Family Wizard.
Okay, okay, Your Honor.
Okay, that's what you use in Sedgwick County, right?
Could it be just any parenting app that works? I know that talking parents for the communication piece doesn't cost them. Our Family Wizard's like $100 a year.
Your Honor, the parties used OFW before, and Ms. Hoffman still has her account.
Oh.
Okay.
Yeah, that's the only one I'm familiar with. And then that's standard still right now in Sedgwick.
Yes.
That's the go-to program.
Most of the
Yes, Your
time,
Honor.
sometimes
Yes.
they have a scholarship program. I've had other judges, approve talking parents.
Okay.
Again,
Well,
the standby is.
when you come up to it, then if we have to address things through a third party or some other way, then you can propose to me other options. But today I'm just going to say, let's go Family Wizard.
We'll do OFW. Yeah,
Okay.
we'll do OFW for now.
Thank you.
And I'll put that in the order.
Thank you. And I'm not going to set another court date at this point.
All right, Your Honor.
All right. Thank you, everyone, for your time.
Thank you, Judge.
Thank you, Your Honor.